This is in part heard and built in a matter of Crabb and others and TUI Airways Limited.
My lady, my lords, before I get back to my submissions, just a couple of housekeeping points arising from issues that arose yesterday. I may hand up 3 documents to the court. Two of these arise from Lord Justice Underhill's quite right desire to get a firmer footing on what in fact happened about the variation of PIP into the MOA. And you'll see the document at 350 is an email from a Mr. Podisar, who was the representative from Balfour, who was leading the negotiations, sending it to a number of individuals at TUI, saying, here's the big suite of PIP documents fully signed. And at the point of signature, that is when they are automatically incorporated. And for the MOA, the 2018 MOA is the one that is relevant for this case. You'll see in the next document, we've said put these in matter of you, but we suggest putting them in the back of the supplemental bundle.
Yes.
So the next document is Schedule B. So this is what old Schedule B looked like when it was part of the 2018 MOA. And I'll take you to the 2018 MOA in a moment. That's that document. And then the third document is a statement from Mr. Crabb, and it goes to the point, if the court wants, the losses that are suffered. And it's the last 2 paragraphs of that statement, paragraphs 49 and 50, which set out, by way of representative example, Mr. Crabb's losses.
And the reason for those losses, specifically the PHI scheme benefit, is the loss of the proportionate payment and probably a smaller element, but still an element, the removal of the automatic 5% enhancement. Is that right?
That's right, my lord, yes. Based on the salary as opposed to then it goes to the benefit of the accelerator.
I still haven't quite, I mean, for the purpose of what we have to decide, I don't need to know, but just so the judge describes proportionate benefit of what it's supposed to do and how it works pretty fully. So you're both content with that. So just for us to be reading it more carefully.
When you start looking at proportionate benefit, you should be grateful to the judge for doing it so well.
Right, thank you. As far as I'm concerned.
Yeah. So, just in terms of just expanding how the variation happened, so you have that, my lord. So if you turn to the operative MOA, this is the one, the 2018 one, at page 69 of the supplemental bundle. If I may just walk you through some of the pertinent points. The first one I'd make is the scope of the agreement is clear. At 1.1 it's restricted to pilots only employed by the company. In terms of the issues before you, my lady, my lord, they're to be found at paragraph 10.1 and 10.2 at page 71, so a few pages on.
So sorry, I was just behind. Which page are we on?
So in terms of the memorandum of agreement,
or whatever you wanted to show us.
The MOA is page 69, and then my lord, the point I was making was the scope at 1.1, which is always relating to pilots.
Yes.
And then specifically, I'm taking you to page 71 and the clause at paragraph 10, clause 10, and 10.1 and 10.2. Because there you will see a 10.1 reference to what you've now got the old Schedule B. And the old Schedule B didn't deal with PHI. It did deal with sickness payment. And the second one is at 10.
So PHI was just in the handbook.
Well, I'll caveat that slightly because at 10.2, the right, because I'll make a point on this in construction, the right itself is a collectively bargained right, and we say that's important for issues.
Yes, so the difference is that we could spend a lot of time on this, which I'm not encouraging you to do. Ultimately, there may be no real difference. 10.1, sickness benefit was always in Schedule B and was quite fully spelt out. 10.2 was always in the collective agreement, but not in the schedule and not fully spelt out in the MLA.
Not fully spelled out.
But it was always understood that there were details and that they would be publicised via another route, i.e. not by a schedule. But same difference, really, because you can always find out what they are by looking at the details provided by the pilot management team, which are in, well, perhaps you better tell us, are those negotiated details, as a matter of fact?
Well,
as to say, does the union know what they are?
No, the union did not, up until 2020, well, that was the point.
Yeah, I understand.
They wanted to have some say in what those details were.
Yes.
So up until 2021, they weren't. They were just TUI wrote them, literally taking them off the plan effectively from the insurance plan, but they were written by TUI.
And that was the point being made by Ms. Mayhew, was that until then, they weren't part of the collectively negotiated.
Yes, and I will say, to a point, she's right, but fundamentally she's not, and I'll explain to you why.
Yeah, and we were
10.2. You look at 10.2 would provide the answer, I say. But
yeah.
So that's the where you'll see that where those schedules get incorporated into. And obviously, old Schedule B is replaced by new Schedule B, and that's at page 200. So you have that. They're still in the supplemental bundle. The first two pages at 200 and 201 deal with what was in old Schedule B, the impaired health points in terms of, well, page 201 anyway, payment during sickness absence. Yep. And then you have, at page 202 onwards, the pilot income protection. Just for completeness, my lady and lords, you'll see there's also Schedule A, which is signed at the same time. Now, Schedule A, I'll come to this a bit later, but picture as we're here, is at page 190 to 199. That deals in quite significant detail with the rates of pay, with bonus entitlement. That schedule, and I don't need to take you to it, but in the 2018 MOA, there is reference in one of the clauses to Schedule A, and that schedule gets replaced by this schedule at the same time as well.
Sorry.
If you want the reference, my lady and my lords, for the MOA, which references Schedule A as well, that's it's at page 70. And it's at paragraph 6, 6.1. It says rates of pay for pilots should be at the scales laid down in Schedule A to this agreement and in accordance with the conditions stated therein. But the point I'm making, two things happen at the same time. Schedule A is varied and Schedule B is changed too. And again, just for completeness, because I'm not sure you were taken to it yesterday, but the operative provision that changes the post-60 in claimants benefits in Schedule B is at paragraph 3.5. It's at page 202. And it's between the two hole punches, and the heading is cover, and it's 3.5 that is the operative provision, absent the issue on carve-out, that we say automatically varies post-60 benefits, but preserves the position for under 60s in claim. That is.
No, that's why the definition of legacy claimant is. The key point is that the definition of legacy claimant says that when you reach 60, you cease to be a legacy claimant.
Yes, and if you want the precise reference for the definition section for legacy,
No, we
claimants,
know
yes.
members made it helpfully to us that yesterday.
And the only other point to clarify before I go back into my submissions is the point on that came up, whether it's not ultimately important, I think, in the facts of this case, but it might be worth having that as background, who the pilots would have sued if they didn't get their benefit. Now, there is, my learned friend rightly points out, a finding of fact, which no one's disputing. It's in towards the end of the judgment. It's not a bit of the judgment you've been looking at. That's at page, core bundle 163, page 306, so paragraph 306, page 163 of the core bundle. And it's one of the issues that resolved, it's not before the court now, but it's something called a linked claim, which one of the individual claimants was seeking to argue TUI should have kept. But it's the last sentence in particular that goes to the point I think Nicholas Underhill was exploring. The linked claim clause in the original sentence was in any event subject to an insurer discretion. It was clearly identified that a pilot could have no legal rights against the insurer, absent potentially if TUI went insolvent, and that was clause 5.5 we looked at.
And I think I remember noticing in passing it would be take to Tesco. Everyone agreed that Tesco was the proper defendant there, not the insurance. Yes, I mean, you do get cases where the only contractual obligation is by an employer is to fund membership of a scheme, and then you become a scheme and you have rights under the scheme against the insurer, trust company, whatever it is. But this is not that kind of case.
That's correct.
Yeah.
I mean, my learned friend was behind me was schooling me in those particular types of insurance arrangements, but also there is obviously an implied term of the trust and confidence that you could get your employer to sue the insurer on your behalf. There is that potential.
Yes, I suppose so. We don't have to.
It's a theoretical potential.
Yeah.
So, my lord, if I just, my lord, if I can just recap where I got to yesterday, and then perhaps map out where I'm going to go today. Obviously, I dealt with the principles of normative effect in sufficient detail, I think, to make the points that I wanted to make about grounds 2 and 3. Just very briefly, just to reiterate on grounds 2 and 3, they're points of appeal that don't really go anywhere because the judge conducted the right analysis by normative effect. And this is a consensual variation. This is the second ground, it's ground 3. We would say there's nothing wrong with the judge having used those terms in any event for the reasons I set out yesterday. Now, if I go back to ground 1, if I may, so I think I started that, I think I finished with the paragraph 10 of Lord Hodges' judgment in Wood, or certainly towards the end, and his guidance or indeed warnings to the court that it's not just taking a literal approach to the actual clause, you have to look at the wider contract. I think it was the extract from paragraph 10. And then depending on the formality, the quality of the contract, you can give weight to the background matrix of factors as the court sees fit. So going to the clause itself, that's it. I'm conscious you were highlighting the supplemental bundle. That's at page 59, the clause 5.1, the supplemental bundle. So I'm just going to go through the literal wording of the clause first, before then going to the wider contractual provisions, and then looking at the background matrix of fact, and through that analysing the claimant's positions and then what the judge actually found. Now, TUI's position is a simple one. That clause means what it says. It's pretty obvious to construct it, and there is only one construction. The first sentence deals with TUI's. I say TUI, it does say the plan manager, but for the purposes of my submissions, I'm putting the two together. TUI's unilateral right to modify, suspend or discontinue. That's what the first sentence deals with. And then obviously the second sentence is the protection linked to when that happens, when TUI exercise their discretion. So we say that's all the provision does. Now, my learned friend makes a point on the heading, and that probably is the right place to start as a matter of construction. Can the plan be altered or discontinued? Well, of course it's broad enough. It could encompass what my learned friend is saying, but headings are generically quite broad, or can be quite broad. But you get the context of what the heading goes to by looking at, because obviously the heading doesn't deal with who and how, but who and how is set out almost straight away. So who, if you're constructing it, you're looking at who can do the change that's referenced in altered or discontinued. Well, it's only the company and plan manager, only TUI. No one else is considered there. Then how is dealt with for the next part of the sentence, that TUI must necessarily reserve the right to modify, suspend, discontinue, in their opinions. Obviously, we say that couldn't be a clearer example of a unilateral right. And it can be the only proper construction. And stopping there, the language of exercising unilateral right is miles away from a collective bargaining or consent. Consent full stop, let alone consent through collective bargaining, which is the complete opposite of exercising unilateral right. Now, subject only to the obligation to consult as appropriate, so even then there's some qualification, but let's assume that it's good industrial practice to consult when you're making significant changes to a key scheme such as this, TUI can exercise that unilateral right. Now, we've always accepted, and the judge deals with this, that if we hadn't done that, then the principles of Braganza, Wednesbury, and not being capricious, etc., and doing it in good faith would apply. Now, what are the consequences if TUI does exercise their unilateral discretion? Well, that flows from the second sentence, and surprise, my lady, my lord, that I'd make this submission, but you can't. The second sentence doesn't sit in isolation. You have to read the first sentence to make sense of the second one. And that is giving protection to what takes place in the first sentence, but only to what takes place in the first section. Now, that's the reference to any change reference is to the first sentence, that change. Because any change could be modification, suspend, or discontinue. It could be one of those three things. And that's where the word any is referring to, or the proper construction of any is referring to that. And again, the reference to any such change is, we say, supportive of our construction.
So this does not cover, or does this not, this provision cover changes effected through a new memorandum of agreement?
No, absolutely. We say absolutely not. And that's what the judge finds, and I'll take you to that in a minute. It's just not engaged on the facts of this case.
So when as you said, the heading is, can the plan be altered or discontinued? And you're saying, yes, it can by a new collective agreement, but that is not intended to be addressed by 5.1. So it's silent as to another means.
Or mutual consent it's silent to as well in the words, which I'll come to. Which the consent.
So there are, okay.
It's not dealing with consent. It's just dealing with the consequences of an employer.
There's one aspect of the way in which the plan can be altered or discontinued, but is not intended to be comprehensive as to how the plan can be altered or continued. No,
because otherwise it would, as I say, it would provide for more other people's other names other than the company and the plan manager. For example, BALPA, or we talk about negotiation rather than consultation.
Your point really is it's simply dealing with non-consensual change. The
unilateral change, yes. Well,
yes.
Yes.
All right.
Yes.
Yes. All right. Yes. two ways of saying the same thing, but against the background that you can always change anything consensually. What you need to provide for is a right to do it unilaterally.
In this case. Or protect, yes. Provide for. The right is provided for TUI to do that, but the protection for in-claim benefits is linked to their exit. Because the point is, it would be an odd feature, if the claimants are right, to have a unilateral right that you would need to carve out different ways of consent, whether that be mutual consent or consent through normative effect. That's why you don't see that language in there, because it's obvious you wouldn't see the language when you're discussing a unilateral right. Now, dealing with the claimant's concession, that notwithstanding there are no words at all about consent, it doesn't prevent what let's call mutual consent in the sense that Tesco used, the provision in Tesco was mutual consent. Notwithstanding it doesn't mention consent, they say you can, it was always obvious it meant you could always change it by mutual consent. Now, you can't construct it to mean by collective bargaining. And we say that's a distinction. Well, there's no good basis for this distinction. First, because, as I submitted yesterday, normative effect is a form of consensual variation.
So what is?
Not a normative effect. I mean, the labels are having an incorporating provision or a seminal provision. You have agreed with the employer that certain things will happen, including.
I mean, it does put workers, employees, very much at the mercy of their union. It doesn't take much imagination to think that Mr. Crabb and the others are in similar positions. Ignore this clause, wouldn't have expected to be in a position where rights that they had enjoyed for some time were reduced by 50%.
Well, in some ways, how much they're reduced, we would say, is not strictly relevant, because have you given the right, or the wrong language?
No, but it's a way of testing just how surprising the result is. It could have been 100%.
But that is the nature of the industrial bargain that's been inherent since trade unions have been a feature of our economic and legal system. that can happen. Theoretically, it can happen. I'm sure you probably ever come across a case where the benefits can be completely lost, but that is the risk you take when you effectively outsource your terms and conditions to what the union agrees with the employer. Yes, it can potentially have harsh effects, but we say that isn't relevant to a proper application of long-established legal principles. So the first point why we say the distinction, you can't really make this distinction, or it's a false distinction, or an unhelpful distinction, is normative effect is a form of consensual variation. The second and third ones go to construction, but they also go to this point as well, that why the distinction is one that can't be made. I've already taken to you this morning to 10.2. The right is collectively bargained. So, I'll come back to that in a minute. And the third point, and I'll expand on in a minute, to have this distinction would be inconsistent with the seminal provision. Now, before I get to those second and third points, my lady and my lord, the case of Amdocs, you were taken to the case of Amdocs and the potential principle that applies from it. If I may just make clear our interpretation. Obviously, one of the court was sitting here up in front of me was in Amdocs. Now, that was a case about a complete failure of an employer to draw attention to the employee that they had a unilateral right to vary. So in that case, there was a complete absence of drawing attention to the employee, and as a result of that, the court said they couldn't rely on actually a term that was never drawn to the attention of the employee in question. It was nothing to do with consent in that sense, construction. It had nothing to say about issues of consent that we're dealing with. It had nothing to do with collective bargaining, that's for sure. And to contrast it with this case, there's absolutely no doubt that the claimants had their attention drawn to the seminal provision in their contracts of employment. The claimants would well knew that PHI was a collectively bargained right because of 10.2. Their own pleading asserts that if changes were to be made to PHI rights, they had to be brought about by collective bargaining. And the reference to that's in Muskin's argument, my lady, my lords. And perhaps most importantly, we say, unlike in Amdocs, this isn't a case where the employer is seeking to rely on a clause which evades liability. And it's also
not a case where the employer is seeking to do what those things.
Evade liability.
What liability?
Evade.
Evade.
Yes,
sorry.
evade. And see, and also the principle is ambiguity is drawn. If you're trying to rely on the clause, is drawn against is held against you potentially. Well, there is no ambiguity on clause 5.1, and I think it's the EAT judge was just referencing the standard common law principle on ambiguity. It's paragraph 68, but I'll find it in a minute. But we're not in that situation. There is no ambiguity on 5.1, the express wording of it. So, if you look at, and I move on to the wider contractual provisions, unless you want me to address you further on the distinctions with Amdocs.
Up to you.
I mean, perhaps I'll just walk through very quickly in stages what TUI say happened and what the judge found happened. So we say 5.1 provides, firstly 5.1 provides the employer with a unilateral right to discontinue PHI entirely or modify it. Secondly, TUI decide not to do it that way, not to make the changes unilaterally, and they elect to negotiate, to bargain with the union and bilaterally agree a solution. So through that process, TUI isn't invoking any provision to evade liability like there was in Amdocs. It's simply using an agreed mechanism, seminal provision, to bring about changes to collectively agreed rights. And again, another point of distinction with Amdocs, collective bargaining is not a provision that evades or limits rights, like an exclusion clause. It simply creates terms that sets out how particular rights are to be negotiated and with who. So, looking then at, before I move on to the wider contractual provisions, on the bare face of 5.1, it doesn't say what the claimant says. It says what we say it says. It's a unilateral right that provides protection when TUI are exercising that unilateral right to claimants. Going then to the wider contractual provisions in this case, well, obviously, part that will be the handbook, but crucially, it's the employment contract. And crucially, it is the MOA. Now, my learned friend didn't reference either of those features as part of the wider contractual analysis you need to do, but plainly, this court does, as per the guidance of Lord Hodge, and in fact that is what the judge does. So if I take you to page core bundle 151, paragraph 262, this is the section where you'll see it oblique, page 150. The heading is, the italicized heading is collective bargaining, potential carve-out, and 5.1. So it's para 262 I want to take you to. I'd already taken you to yesterday in terms of the judge asking the correct question question about whether normative effect was engaged. But it's the second bit of that paragraph that starts just after the footnote 31. So if the provision, sorry, my lord.
Yep.
So it's the second, halfway through paragraph 260, you'll see the footnote, and it's the bit after the footnote. I'll just take the court to, if I may. So if the provision in paragraph 5.1 furthermore, which purported to protect benefits which were being paid both pre and post 60, had been intended to provide a carve out from any future collective agreement, thus nullifying the provision in the contracts of employment which allowed for incorporation, specific wording to this effect might reasonably have been expected. We say that is the judge there rightly taking into account the seminal provision and how important that would be to the reasonable observer trying to understand what 5.1 meant. Because as I took you to Mr. Gavin's clause yesterday, as representative of the other claimants' clauses, it's an express term that doesn't qualify at all changes brought about by collective variations. So the reasonable observer would note that too, not only the existence of the seminal provision, but it's without qualification to change. And we say, just looking at that, the reasonable observer would say, well, then I would surely expect, given the existence of the seminal provision, words to be put in to 5.1 to carve that out, or circumscribe or better. And that is exactly what the judge is finding in that section I've just taken my lady and my lords to. The next point I want to make on the wider contractual provisions and why they drive to support our construction of 5.1 is that 10.2 is a collectively bargained right. So the reasonable observer would have regard to that fact and would think it was an odd construction to say 5.1 was to prevent TUI and Balfour's ability to collectively bargain the right itself, because you'll recall that it's not just to modify, it's to discontinue the scheme completely. So the reasonable observer would find that a strange feature, that here you have the right derived from 10.2. Balfour and TUI collectively bargain the right itself. In theory, they could remove the right completely. But the handbook is, or 5.1, is circumscribing and fettering their right to do that at all. Now, the reasonable observer would think that is odd, and they would expect words to be put into 5.1 that not only deal with the seminal provision, but also deal with the implications of that as well. Now, my learned friend made much of this point, that because the handbook rights, the right, get the right to collect one, because the provisions in the handbook setting out the basis for the right was net collectively bargained, the reasonable observer would come to the view that the pilots couldn't possibly have agreed to carve out their rights in the handbook, because they weren't, those particular provisions weren't collectively bargained. But we say that analysis misses the fundamental point that the right itself is a collectively bargained right. Now, importantly, if I take you to how the claimants or how the parties asked the judge to decide how the handbook was incorporated, it was through 10.2. Now, if I take you to the list of issues at page 100 of the core bundle, so the list of issues is captured in the learned judge's judgment. It's at paragraph 68, page 100 of the core bundle. And you'll see list of issue 1. And the very first question the judge was asked to decide, and did decide, was were paragraphs 2.1, etc., expressly incorporated into the claimant's individual contracts by clause 10.2.
So which paragraph was
Sorry, my lord, it's the top of the list of issues.
Where's the list of issues?
Here, it's at paragraph 68, page 100.
Sorry, I was looking at 168. It's okay.
And if you see the mechanism, the mechanism by which the parties agreed the judge had to decide how the handbook was incorporated, it is through the collectively bargained right at 10.2. So or put another more simple way, the PHI terms in the handbook are come into force, are incorporated into the contract of employment through collectively bargained right. And perhaps I'll leave the holiday point you made yesterday, Rod. I think I've made.
Well, leaving what point?
You made the holiday point. You probably don't recall.
Don't assume any of my points that they were testing things. So if it's what you want to make, you must make it.
Well, it goes to this, and it's very much grounded in what I'm saying. Either through amending the seminal provision or through or having the clear words in 5.1, you would expect that qualification. I think you may or may not recall that you were talking about amending and incorporating provision, said all collective agreements, changes to collective agreements will vary your terms and conditions, except for holiday pay, for example. And that's what we say the reasonable observer would expect, either in the seminal provision or
I've got the point,
You've got the point, I'm grateful. And yes, the purpose of the scheme is to provide a valuable benefit, but it doesn't mean it can't be agreed and changed through agreement. So I think that would be the point on the reasonable observer looking at that. And the same point goes to permanence, the reference to permanence, to meet the incapacity definitions and or still be employed. But the word permanent is used, doesn't mean you can't agree to change a benefit that is permanent. So those are the points I want to make on the wider contractual provisions, which we say overwhelmingly support the judge's analysis and or 5.1 and the facets and analysis he carried out. Now, it is obviously a matter for the court how much weight you place on the background matrix of fact in a case such as this. We say the term is pretty clear. You read the rest of the contractual provisions, there's not really much you need to look at with the rest of the background matrix of fact. But if you did, if the reasonable observer, strictly speaking, did look at the background matrix of fact, they would notice the following key features. First, this is a heavily unionised workforce. Secondly, and linked to that, terms and conditions were invariably altered through the process of collective bargaining, and that's why I took you to Schedule A, which deals with pay and bonuses. So just stopping there, with that level of regularity and the agreed mechanism as to how changes are made to terms and conditions, the reasonable observer would expect to see the wording in 5.1 expressly carving out collective bargaining. The reasonable observer would also understand that, as per paragraph 42 at the front, I'm not expecting the reasonable observer to have read Justice Elias's decision, but there are winners and losers in any collective negotiation, and that you don't need to expressly consent, as in the mutual consent, for changes to take effect if there is that
You're right, of course, that there are point you make about winners and losers, but it is very unusual for the union to agree that a group, maybe only a small group, but a group of those whom it represents, should have their income cut by half.
Well, that depends on the facts, of course, and what you won't have got perhaps yet is PIP was going to be a self-funded scheme, so all the pilots were going to be funding. So what the people, the non-incapacitated pilots were funding the pilots already in claim, and there was an issue that the unions had an issue, or the members certainly had an issue, the unfairness of proportionate benefit. It was too generous, and it was potentially unfair to those union members who are now self-funding it. So, my lord, theoretically you're right, but obviously every case depends on the facts, and in this particular case, that's why BALPA did what they did.
Yes, I saw a bit about self-funding. I suspect this is the particular point about the union, or some members of the union, regarding what they would see as the subsidisation of those on with PHI or the PHI equivalent as unfair. did that come up in the context
Yeah,
of the trust and confidence?
Yes, it comes up in all the minutes and these.
Well, we haven't got those.
No, you haven't. Yes.
No, but when the judge's findings, I'm more interested in.
As in.
The judge had to make the trust. I haven't really grappled with how the trust and confidence argument went, but I'm assuming, on the basis that if you won on 5.1, they were saying, well, even so, you should not have agreed with BALPA, even if BALPA were willing to do it, a term which had this effect, breach of trust and confidence to do so. That was the shape of the argument, wasn't it?
Yeah.
Was it? I don't know. I wasn't there.
Can I pause for talk? Because I, like you, I haven't really engaged in that second bit, the trust and confidence bit. I'll get Mr. Edge to. Sorry,
you weren't doing it below.
No, I did. No, sorry, I don't mean I did. In terms of for this appeal, I haven't got my head back into that section of the judgment. I'll get Mr. Edge to look at it to provide the answer to exactly how it was put. But going to your point that issue 11. Issue 11, I think. Great, very great. So what page is that? 101.
That's how the claim was.
Well, yes, I see. So issue 11 feeds off issue 9. So the premise of issue 11 is if the claimant's contractual rights were able to be varied through collective agreement, did the defendant, TUI, breach such terms, that's the trust and confidence terms, effectively by negotiating a deal which so disadvantaged the claimants? I'm just trusting my eye over those.
The fundamental way it's lost is that they were exercising with discretion. Then the specific arguments on trust and confidence really get down to failure to consultation. So it wasn't really a standalone argument. You should never have done. You should have done this agreement. It was really a waiting agreement.
Right.
Yeah, most of them are rather specific points, yes. But the biggest one, by allegedly changing the PHI scheme, the argument there presumably was you couldn't have negotiated this particular change.
Yes.
Effectively, the withdrawal of proportionate benefit.
Yes. And what was in the minutes and discussions between BALPA and its members was the perception that to get the generous benefit, proportionate benefit, you only had to earn a 10 grand job, or you had to do a small job to get the maximum benefit, 37.5%. You got like the think of figures that you did 10,000. If you did a job earning £10,000, you then got the 37.5% of your previous.
Speaking for myself, I wanted in big picture terms. I just want to understand whether the point that you made to us a few minutes ago that the unions representing presumably a majority of their members, believed that if they were going to have to self-fund, that's the premise of the whole thing, it was unfair to the pilots who were still flying to fund proportionate benefit. That's really...
Yeah, it was part of the reason why they urged...
I'm not going into the rights and wrongs of that. It's not what we're here to do. I just want to know whether that was a live point in front of the judge in connection with the trust and confidence part of the claim. Was there evidence about the union felt, what the union's motivation was for negotiating such a deal, right or wrong?
Yes, because I remember cross-examining about this.
Right.
Questions were asked about this because there's documents we
speaking for myself, that's all I need to know. I don't want to open up this whole area, which isn't. But I just, as you say, it's background. And what I understand you to be saying is that it's not just a general point about winners and losers. There is a reason why, rightly or wrongly, the claimants group were regarded by the union as losers.
Yes.
don't mean that rudely.
No.
People who it was right to sacrifice their interests to some extent in making
Yes.
the deal. Yeah. Okay. Thank you.
There's another point that my learned friend seeks to rely on in the background matrix of fact, and it's clause 3.27 of Schedule B. Now, the first point I'd say is that's impermissible because you can't rely on something that comes many years later. And if we're constructing what the 2015 handbook means, in particular 5.1, you can't rely on something that is in a document 6 years later. So the first point is it's not permissible as a matter of law. But in any event, it goes really to this point. What was 5.1 engaged by what TUI and Balfour did? And it wasn't, because it wasn't an exercise of a unilateral discretion. So the introduction of KIT couldn't have been inconsistent with 5.1. Now, I see you've turned to 3.27 in the schedule.
Which page?
Page 204. First point, it's not permissible for the court to be looking at this. Second point, it wasn't engaged. But even if you are trying to construct what 3.27, all it's doing is simply saying for under 60s, PHI will continue.
So which page are we on?
Sorry, page 204 of the core bundle, my lord.
Yes.
And it's at
the
top
core
of the page.
bundle.
Not core bundle, supplemental bundle.
Yes,
Apologies
cool.
for
Yes.
confusing everyone. Yes, page 204 of the supplemental bundle.
Yeah.
At the very top, 3.27. This, you'll recall, this is a point my learned friend was
Yeah. Certainly,
relying on.
yes.
And all that is in a collective agreement, Balfour and TUI have agreed that under 60s PHI claim will continue, and it won't for the over 60s. We see that point wouldn't assist the reasonable observer in any event. Now, I'll very briefly take you through how the judge analyses this. So you've got the key paragraphs when you're considering this. I've already taken you to paragraph 262. Now, the analysis starts at paragraph 247, which of the core bundle, which is at page 147. You see that it's headed paragraph 5.1. There are two parts which he deals with construction. This is one section, and then the next section is on page 150, where it's headed collective bargaining and potential carve-out 5.1. But how the judge analyses the clause, paragraph he refers to at 247, about if it's incorporated, and he's absolutely right, so it contains two separate rights, one of the company and the other of the employee. And then at 248 and 249, he goes through, 248 deals with how it came to be that the over 60s were self-funded rather than insured. So he notes he had particular information before the court on those points. But he makes the point at 249 that whichever the source of the benefit, there was a seamless process where pilots continue to receive the benefits, and if appropriate, proportional benefit for the company payroll will stay to the age of 60. And the paragraph ends, or towards the end, going, despite this, that the handbook made no differentiation between the insured and the company funded benefit recipients. Then if you turn to paragraph 250, the first bit of it really goes to construction. It seems to me the only way in which the protected benefit provision can be interpreted in 5.1 is by the inclusion of both the insured pilots under 60 and the company funded pilots at 60. over 60. And he said, in other words, in the absence of any consensual variation, obviously that's an issue in the case, what that means, this provision was assuring in-claim pilots, regardless of age, that they would be protected from unilateral change, modification, etc. So that's how he's constructing what the clause means. You then turn to 250, or paragraph 250, which is where he's analysing what the protection is in the second sentence, although he calls it the final sentence. In seeking to attribute a contractual construction, I've come to the conclusion that the protection afforded by the final sentence, which is counts in sufficiently certain language that satisfies the test of applicants, because he's dealing here with incorporation issues, whether it's incorporate, applies to any pilot who's in claim, and again, they're subject to consensual variation. The contractual intention is sufficiently clear, that the company could change, with appropriate consultation, the way it provided PHI benefit to future claimants, but not those to in claim, affording the latter some degree of assurance or protection. So, my lord, that is how he construes, that's how the learned judge construes clause 5.1. He then constructs it a bit further from paragraph 259 onwards. That's at page 150. And paragraph 260 I want to take you to. The starting point, it seems to me, do you have that at the start? It seems to me it's not the claimant's protection.
Which page, sorry?
We're on page 150, my lord.
Yep.
This is paragraph 260.
Yeah.
And where the judge is analysing this in this way, the starting point is not to start with the protected benefit clause. He's talking there of the second sentence, but the employer's right to modify. And obviously that is a permissible approach and a sensible, logical approach, because that's the way the sentences are written. And he makes the point, there's no doubt this gives rise to a discretion if exercised on a unilateral basis, in reference as Briganza and Dalglish, the discretion point. And a bit further down, it is self-evident, however, that although the defendant was entitled to impose changes unilaterally, provided there was individual collective consultation, this is not what happened in this case. In my judgment, there was no discretion exercised by the employer for the process where effectively collective bargaining. And in this respect, I agree with counsel for the defendant. So, my lord, he's rightly saying that's not what happened in this particular case. On the facts, he's absolutely right to have held that. Paragraph 261 is where he notes, towards the end of the paragraph, the concession that the claimants made, that it doesn't prevent mutual consent, change by mutual consent. I've already taken you to paragraph 262 and how he grounds his construction and his point on what I'd expect clear words through the seminal provision. And then finally at 263, he just makes the point again, as far as there's no discretion exercised when the PIP changes were introduced, because those changes are not brought about a unilateral decision but by consensual variation. And then he goes through the consequences. Having properly taken himself back at that paragraph to the contracts of employment and the seminal provision. So, my lord, we say that analysis, my lord, he doesn't betrays no erroneous construction in terms of what the words say, in terms of what the wider contract says, in terms of the background matrix of facts, and actually locating it in what actually happened. It was collective bargaining, not unilateral change. So that is why we say clause 5.1 can't possibly be constructed in the way my learned friend urges this court to do so. I'm conscious I said I'd be an hour and a half, so there's about another half an hour. So if I move, unless there's anything else I could assist on round one.
Don't think so. Thank you.
Great. Ground four on the point on aptness, as now I understand that this is really another way of putting ground one, that PIP couldn't have been introduced, or 3.5 Schedule B couldn't have done what it did because it was repugnant or it was inapt given their construction of 5.1. Well, we say that stands and falls with 5.1. If the point is still being made as I'd previously understood it, that it wasn't, the judge failed to consider it aptness, well, you've got myself and Mr. Edge's submissions and our skeleton why we say that wasn't an issue that was properly put before the court in any event. But if the PHI provisions were apt, and that took for incorporation, which is a submission of my learned friend that was accepted by the judge, then plainly its successors, the PIP provisions, must in theory be apt for incorporation for the reasons I set out in my skeleton, the certainty of them, the importance of them, importance to the contractual bargain. So I don't propose to say much more on ground 4 before I move on to 5 to 7, which is really this issue on paying the pilots their PHI benefit at a pilot rate until their statutory pension age. Oh, right, yes. Mr. Edge makes a fair point. I didn't take you to paragraph 41 of Tesco, which I'll just give you the reference to, which it supports our submission. There's no magic to change, to agreeing to change accrued rights, or collectively agreeing to change accrued rights. And that's what paragraph 41 says. Just so you have that reference of Tesco. Again, I don't think the court's completely understood the chronology in play with the reference to statutory pension age. So I'll just give it in terms of the different handbooks. We have a handbook in 2008 that doesn't reference it. The bits in brackets in the paragraph that relates to the pilots. But it does go into the 2011 one, remains in the 2015 one, and as I understand, I think comes out in the 2018 one. 2019, I'm grateful.
Sorry, so it doesn't refer to the 2008, comes in
11, stays in the next one, 2015. Was there one in 2018 or was it just 2019? I don't think so. No. And then it comes out in 2019. So just so you've got the key chronology there.
Thank you.
My lord. Now, the 5 and 6 are effectively the same thing. They're really bad. What does it mean? But I'll take 6 first, because obviously if it wasn't apt for incorporation, then you're not really in a position having to construct the thing, either doing ground 5, they arguably end up doing the same thing. But now, the judge's analysis on aptness, I think it's probably important to start how he deals with it. This is, there's no, as I understand, I'll be corrected if I'm wrong, but there's no criticism of the judge's understanding of the law in terms of setting out the law on aptness and incorporation of rightly and appropriate concession. He places particular reliance on one.
Okay, well, you know, I've got to be in my bonnet about what aptness really means. Clearly, has expanded a bit from how it was originally taken. But the important thing is what it means or how it bites in this case. Am I right that your approach and the judges, and you therefore say the right approach, is that the aspect of aptness with which we're concerned here is inconsistency with the purpose and other provisions of the contract?
Yes, in the handbook, yes.
Yes, of the handbook. So what, in my old-fashioned way, I call repugnancy, what the judge calls an anomaly.
Yes.
But that's what we're talking about aptness.
Yes.
When we're not talking about the other kinds of aptness at all. It's not. We're not talking about should you put in. Is it apt to put into a private, into a contract between the employee and the employer, provisions about union office facilities or that?
Yeah, he says it doesn't make commercial. It makes
no. I understand that, but I'm sorry. I did. the whole label of appellants confuses me, and I want to know what the real point here is. The real point is, can we use the label inconsistency or?
Yeah, it's so inconsistent it wouldn't make sense.
Yeah. Okay. Thank you.
And that's probably the simpler way of describing it. Now, you'll find that his analysis. Just make sure I've got the right reference before I take you to it. Yes, it starts at paragraph 253, my lord. Page 148 of the core bundle. My lady, my lord's, apologies. So that it's headed, you see SPA or 65?
Yeah.
Yes. Yeah.
It's applying how he dealt with that, and his interest of that. So he captures what the claimants were submitting. Well, he says on the face of it, and I'll come to whether he's actually right as a matter of construction, it appears to extend the payment of benefit. Now he's not, and this is quite an important point of distinction, whether it's pilot benefit or non-pilot benefit, he's just using the word benefit there, to the higher SPA for which all these claimants will be older than 65, in most instances 66 or 67. And he notes, notwithstanding the fact that commercial pilots cannot legally fly after the age of 65 under civil aviation rules, and there's no dispute that is what the law is, you can't fly a commercial aircraft after the age of 65. And I'll give you the reference for the relevant EU directive that still is a feature of our domestic law. That's in, don't need to take you to it, but that's the authorities bundle, tab 30, page 396. And then the judge here is grappling with that inconsistency point and how it can't make sense. If the claimants are correct in their contention as to how these paragraphs should be construed, they will be entitled to a benefit which was intended to cover their inability to fly for medical reasons beyond the period in which they would have been allowed to fly in any event. That's a perfectly appropriate way of framing the key suggestion by the
So which paragraph are you reading from?
So that's paragraph 253, my lord, and it's
Sorry, I must be going mad. I can't see that.
it's at the end of the paragraph. So
Oh, right.
So you've got notwithstanding
Yes,
the
no,
fact
I find it now. Sorry, yeah.
and then you've got the bit here capturing what
Yeah.
the logic is of what the claimants are
Yeah.
saying. Is they're going to be able to be paid pilot PHI after a point at which they couldn't legally be a pilot, and that's the first grounding of the judge's point where that he sees that as frankly absurd or inconsistent. That's fair to that. And then at 254, in my judgment, applying the same considerations to incorporation of contractual terms from such material, it cannot have been the intention of the parties. And he talks about, apart from the fact it makes no commercial sense to provide a benefit to cover a salary shortfall which would not have been earned in the absence of sickness capacity. He then references the historical nature of the benefits, and the overall application to the employees cannot be ignored. Now, he references at paragraph 255, there was no suggestion prior to the handbook being amended in 2019 that any of the pilots thought they were entitled to be paid to non-pilot, pilot PHI to the statutory pensioners. He's capturing that at 255. Then at 256, which is quite an important paragraph, it's quite correct that the option of a higher SPA specifically refers to pilot in paragraph 2.1, but it's acknowledged, my own friend said this yesterday to you, that paragraph 2.1 and 3.1 as well is relating to all TUI employees, apart from that one paragraph, including those who are able to work beyond the age of 65 in the ground-based role. While this did not appear to be, here's a key finding of fact, my lady and my lords, not accepted by the claimants, i.e. that they would get a ground-based role as of right. He finds, I'm satisfied with the balanced probabilities that there was no assurance of the ground-based role for a pilot who became compulsory unable to fly at the age of 65 and thus retired from the company. So he's referencing there the compulsory retirement age that TUI operate for pilots, And I'll get the reference in a minute, my lord, what I do have. But in the judgment, he makes the point that the claimants would have been aware of their mandatory retirement age because it's on their pension statement and it's on their payslip, I think is the reference.
So it said, what's on their pen?
Their mandatory retirement age, saying they're going to be retired at 65. So the judge is reliable. I'll find the reference in a minute, but in this judgment, he's referencing.
So you told us yesterday there was no contractual retirement age.
No, I don't accept that.
No,
in the sense
there isn't one mentioned in the contract of employment, but there is nevertheless one you say.
Well, in the 2008 memorandum of understanding of agreement, there is reference to mandatory retirement age for pilots of 60. Now that changes in the sense that that mandatory retirement age goes up to 65. So we don't accept. TUI operate a mandatory retirement policy of pilots for 65.
So you don't accept that?
We accept. So we don't accept. We operate that. We operate it in that way. That if you're a pilot and you.
Okay, what I'm writing down is there is a policy, published policy, of mandatory retirement age at 65
for
pilots. Mandatory retirement.
Absent finding an alternative role. And that's what the judge is talking about with the. It would have to be a ground-based.
So I agree. This is important to answer the same thing. There is a mandatory retirement age as a pilot at 65. That may not mean mandatory dismissal because you may be found an alternative job.
Yes.
Yeah.
But you need an alternative job, and that's why I took you to that finding of fact on the balanced probability. The judge is saying there wasn't any assurance of a ground-based role. And the point I was also making is there is reference in the judgment to the fact that the pilots would know that at 65 they won't be able to fly as a pilot because it says so in their pension statement and in their...
Okay, but to come back to that policy, are you saying that that policy is contractual?
Well, they can't fly as of law beyond 65.
Yes, right.
So...
Yes, I see.
There is, perhaps it doesn't matter, but for example, Mr. Crabb, my then friends have shown me, in his contract of employment, Mr. Crabb is told his retirement age is 65. And we can print that off for you if you want.
No, it doesn't. I'm not sure how much all this matters, but just
it probably doesn't.
Firm ground.
But the firm ground is really this. TUI dismiss all their pilots at 65 as pilots, and they're likely to be dismissed from employment unless there's an alternative role.
Well, they will be.
Well, there will be, so yes, likely they will be, unless there's, and the judge's finding of fact is that there's no assurance that will happen.
Is there a mandatory retirement age higher than 65 for ground employees?
I'm not sure. I'll just have to check whether there is even a mandatory retirement age, whether that would be... Is this a state pension age? So I'm not sure that would...
There's been a lot of law about whether what happens if you retire someone, say, well, you've reached your state pension age, so you must... you used to lose your unfair dismissal protection at that point, but that doesn't necessarily mean that it's a contractually correct dismissal. Anyway, we needn't get into it.
No.
Okay, fine.
You can be assured by the judge's finding of fact that TUI operate a mandatory retirement age, so absent...
Yeah, okay, as a pilot. Yep.
As a pilot and absent...
That's all that matters. Yep.
That's all that matters. Because he then goes on at paragraph 256, if you go back to it. In any event, there was an option for alternative suited employment for an incapacitated...
By the way, is suited a term of art within TUI, meaning... someone's wearing a suit rather than a uniform, like an office, or does it mean, is it a slip for suitable?
It's suitable.
I rather like the idea of suited employment.
Or gowned employment.
Men in suits. Yep, okay.
So,
or women.
For an incapacitated pilot who would have been dismissed, retired at 65, the salary would have been substantially less than that of a pilot, and there would have been the incongruous result of that incapacitated pilot receiving substantially more than he would have been able to receive if he remained able-bodied and had secured an alternative role. And again, that's a matter common sense, we say, that would be the case. That you would be getting benefit at a rate higher than what you would get as a non-pilot. Now, 257, the judge doesn't feel he needs to deal with my submission. He doesn't need to make the finding he does, which is, well, none of the pilots were going to be here post 65, so they wouldn't satisfy it. They'd be dismissed. You've seen being taken to 3.1 and 2.1 yesterday. Principal eligibility is you have to be employed to get to receive the benefits. So my point I was captured 257 is they wouldn't have been employed because they would have been dismissed, therefore eligibility would cease. But he says he doesn't need to deal with that point because it's so obvious that if you look at it, it says the intention of the parties. So, paragraph 257, it starts just towards the end of the paragraph. In my judgment, not the end, but I think your page references might be different. You've got, in my judgment, it is sufficient. Do you see that? In my judgment, it's sufficient to consider this potential contractual provision by reference to the intention of the parties in the absence of. It talks about the intention of the parties, that's 3.1, this replacement salary. Now, my learned friend yesterday seemed to be advancing the submission that actually means a salary, but it's a replacement salary. The word's underlined, so in the context of being on a PHI scheme, it's never going to be 100%. So leave that submission where it is. This benefit is designed to act as a replacement salary. This is what had been expected by pilots who are no longer able to fly, and the windfall of a benefit extending beyond. So he uses the word windfall, my lady and my lord, of a benefit extending beyond their normal flying age made no contractual sense. Thus, it would fail to pass the test. We'll just send it as the.
Sorry, just now for another factual question, which I've been meaning to ask. In the period with which we're concerned, what was the range of possible SPAs? They'd be different depending on the circumstances of the individual, wouldn't they, I think?
Yes, I think it's between 66 and 67, was it, the range? Is that right, at this time? Or was it 68?
66 to 68.
68 to 68.
Okay, thanks.
So, having taken you through that analysis, that there's plainly no error of law in the way the judge applied it, and it's a matter of common logical sense what he says. In terms of the construction point, that's ground 5. Effectively, I've arguably dealt with most of it, but there is a point I would like to make, and it's just that if you properly construct the words, it doesn't actually have the effect the claimants say it does. So if you look at supplemental bundle, supplemental bundle, page 54. This is 2.1. I think it's important to understand how the whole of these 4 paragraphs work, and what the proper construction would be with the Court of Appeal.
So where are we doing now?
So 2.1, bundle, supplemental bundle, page 54. So, am I eligible for cover? It's eligibility for cover. Now, I'm just going to briefly walk you through what we say the appropriate construction of all of this paragraph is. So, am I eligible for cover? Well, the first one, your eligibility is determined by your contract of employment. That went to the point I made to the judge that obviously if you're dismissed for cause, then your eligibility falls away. And obviously dismissal for cause, as long as it's not, well, it couldn't be for cause if you were dismissing that person because they're in incapacity and or to stop paying the PHI. But it would obviously deal with a situation where a pilot can't fly at 65 and there's no other job for them. You haven't been taken to the second paragraph, but it's important because to be actively at work, you see, to basically get cover or increase cover, for example, following a salary, you may be subject to the insurer's standard actively at work condition. Now, what does actively at work mean? Well, in some ways it's pretty obvious what it means. You have to be at work. So you couldn't, you have to have been at work, I suppose. I don't actually know whether it was for 1 day or 3 days or 3 months. I don't know the limitation period. But to get the cover in the first place, you'd have to have gone to work for a period of time and done your job. And then to get any increased cover, you'd have to, I've even gone off, come back on from incapacity, and then gone back off again. But it's the actively at work definition that's important because it arises in the last paragraph, which I'll take you to in a minute. Now, the second paragraph, you'll generally cease to be included in the plan when you reach 65 or have higher state pension age, or earlier if you cease to satisfy the eligibility conditions. This is a paragraph that deals with everyone in TUI, all employees in TUI. If you leave the company, you'll also cease to be eligible for inclusion in the plan. Now, briefly, just turn over to page 55, which deals with where the judge has referenced a regular income benefit while you remain in the company's service. It's designed to act as replacement salary, and it's payable, and it gives the four.
Where are you reading from?
So the top of 3.1, my lord, the page over.
Yeah, thank you.
The reference to act as a replacement salary. It's payable until the earlier the following of those four things: return to work, your incapacity ceasing, reaching your 65th birthday if higher state pension age, or your death. So expressly setting out when it's paid in full. So taking you back to page 54, the third paragraph is the one that's specific to pilots. If you are a pilot, so specific pilots, whilst you will be eligible to be covered on the plan until you reach age 65, and then it's the key bit that gets removed in the 2019 handbook, or if higher your state pension age. On reaching 60, you'll cover any benefit in which becomes payable will be provided in accordance with the plan company rather than insurer. That says what it says. But it's the next paragraph that you have to read, the third paragraph. Obviously, if you leave the company, you'll cease to be eligible. But please note that on reaching age 65, if you remain employed by your company in a non-pilot capacity, so that reflects the reality that for a pilot, well, the pilot would stop, the claimant was a pilot, they would stop being a pilot, and they would be, if they were to remain in employment, would be in a non-pilot capacity. And you're able to satisfy the insurer's activity at work requirements. So what that is saying is at 65, let's go through the theoretical possibility. There was a potential offer of a ground-based role for the pilot. They would have to go back, they would have to be fit to go back to work. They would have to meet the insurer's activity at work requirement to get that benefit. And then it says you'll be eligible for continued PHI cover, which would then be insured in line with the standard stance for pilot members. So there is simply no basis, if you construct the term, for the pilots to claim that their PHI to 66, 67, 68 would be anything other than for non-pilot members. That's what it says. It couldn't be clearer. But they'd have to go back to, well, first of all, they'd have to have a job in the first place, finding the fact there's no assurance. But secondly, they'd have to be physically able to go back to work and do it. And then they'd have to go off again. They'd have to meet the definition of incapacity. But if they did go off again, it would be as a non-pilot member. So just as a simple construction point, my lord, Martin Court of Appeal to approach, the claimant's case doesn't work. And it's no surprise, really, in the sense that, for example, a number of the claimants, to be a pilot, if you have any issue, like if you have migraines, and a number of us, I suffer from migraines, but I could never be a pilot because I have migraines. Now, it doesn't mean I can't, and I wouldn't be, and I would if I was a pilot, I'd have lost my license, as some of the claimants did, or symptoms like migraines. But if you have a migraines, it's not going to prevent you doing a ground-based role. And I think that is what that fourth paragraph is getting at, that theoretically, yes, you'll stop being a pilot, you'll have to come back in a new job, which is a non-pilot job, and theoretically, a lot of the conditions that claimants had wouldn't prevent them, they wouldn't be incapacitated to be able to do that. And then if you did go off on incapacity, it would be at the non-pilot rate. So even if the judge was wrong to find that inconsistency, if you just actually analyse what's being set out in that in 2.1, it doesn't get to where the claimants want it to get to. They're never going to get pilot PHI beyond 65. If I capture it in that way. I'm bang on time, so I've got 5 minutes. So the ground 7 I can deal with very briefly. That on the judge's findings, the SPA was never incorporated. First point, so there isn't an inconsistency. The second point is it doesn't survive the incorporation of PIP, the normative effect. And if the judge is wrong about this, it's really issues of construction. And I don't want to dive into Eastern Pantiles and how mistake and construction, but it's not like a rectification exercise. The court can read words in that aren't there if they think there's a mistake. I think it's an obvious mistake. That's what the judge has done. And
it's not quite how he's put it, is it?
no, but I could certainly make an argument for that is that if you need to go there, he said it gets corrected. He does acknowledge it gets corrected because it wasn't meant to be there. Doesn't expressly say it, but that's only an acknowledgement. He's finding that it's a mistake to be there because it didn't make any. It was obvious to the reasonable observer it shouldn't have been there, and that's the construction that we say you should make. So, my lady, my lords, those are all my submissions. I think just in one very brief point to summarise. The appeal can be disposed of by both on construction and variation on just the seminal provision. It begins with this case, as it did in first instance and still does, begins and ends with the construction of that seminal, with the words of that seminal provision. It's a crucial aid to construction as to why 5.1 doesn't mean what it says, and it provides the automatic variation of the claimant's PHI terms from to PIP. So unless can I just check with Mr.
Yes,
Evans?
have you said everything you want to say or incorporated anything you want to say about your respondent's notice?
As in sense of what I've
Submissions you...
Yes. Yeah, make sure I've captured them. That's in core bundle, isn't it?
It is, page 40.
Page 40, I'm grateful. No, my lord. I believe we've said what we needed to say, unless you think I haven't. But yes.
Do you have anything else?
I've just got one point I meant to mention yesterday, and I'm sure you can deal with it. It may technically be a point from Ms Mayhew. We started off with 8 claimants. In the title to all the proceedings in the Court of Appeal, 3 are crossed out. What's the position? That there were all 8 were suing in the High Court, and 3 of them have chosen not to appeal further.
Correct. One settled. Oh, but before, yes. Yeah, there was a 9th.
I see. Well, no,
But your question goes to the...
Sherpa settled. It was originally 8.
Oh, was it?
Sherpa settled.
Right.
And then on top of that. So
But it doesn't matter.
It doesn't really matter.
Again, it's just setting out the nuts and bolts in the judgment.
Yes. Those 3 are no longer parties to the...
So the background doesn't matter. The 5, we are now concerned with 5. Mr Crabb, Mr Gavin, Mr Rawlinson, Mr Sneath and Mr Bishop. Is that right?
Yes.
Yeah.
Thank you.
Thank you.
Yes, Ms Mayhew.
Thank you. If I may come back first of all on a point that has just been made in relation to paragraph 2.1, which is at page 54 of the supplementary bundle. And it's the point in relation to the last paragraph, paragraph 2.1.
Yes.
We've been taken to the Respondent's construction. I just want to make the point that if that construction is right, there would simply be no necessity to have the paragraph that's immediately above it, I believe, which is the pilot paragraph, talking specifically about their rights to reach age 65 or apply your state pension age. And I say that is indicates strongly that the construction that's you've just been talked through is inaccurate, and it's not narrow in the way that my learned friend suggests. In fact, just to remind you, obviously the policy relates to not just pilots, and therefore this is a broader policy applying to all non-pilots that are covered by it. That's the first point I want to make. There's a second point that was raised around what union members thought of proportionate benefit, and there's a paragraph in the judgment which I think will assist, and that's at the core bundle, page 93. It's in the section where the learned judge...
Just wait for us
Of course.
a second. Yeah.
Page 93, paragraph 50. And just, you can see just towards the top of the page there's a heading, PIP, Public Protection. And this is essentially the background to how PIP was negotiated and brought into effect. Paragraph 50 touches upon the concept of self-funding becoming central to discussions. And it talks about what the structure would be, and towards the bottom of the page it says, in the course of the negotiations between BALPA representatives and TUI management, it was considered that this would be welcomed by the pilots, then had a vested interest in the scheme. I think the question is whether or not any pilots themselves have expressed that. My learned friend said he cross-examined my pilots, but of course they can only represent their own position, which is plainly that this wasn't in their interests. So I don't think there's any direct evidence on what pilots actually thought.
No, it's my fault. Well, it's not my fault. I raised this simply because it was being referred to as relevant background. We don't speak for myself. I won't be making any findings about that. But there is a passage in the part dealing with terms and conditions at para 268, which appears to make findings about Bulper's approach, because it's perhaps, it's a bit difficult to tell, implicitly critical of Bulper's approach.
That's how I took it.
Yes.
Yes.
But his point is, well, this is water under the bridge. We're not appealing. You're not appealing on this point. That the employer can only deal with the union as it has it. If it's going to go by collective bargaining at all, if the union takes this approach, that's the approach they negotiate with. But if there were to be a reference in the judgment to Para 268 by way of background, showing that the judge appears to have been critical of Bulper's approach, that's your understanding as well?
Yes.
Yeah, thank you.
If I can then just, there is one further point, I don't think we don't need to turn to it, but at paragraph 255, there is a comment made by the judge about there not being any contemporaneous evidence of the pilot's position in relation to the retirement age. That is covered at paragraph 52 of our deal skeleton, but also there is a paragraph 175 where in fact the judge makes a finding which he then doesn't bring in at his paragraph 255. It's just a small point, but one just to make sure you have in front of you.
So which paragraph is that?
So it's paragraph 255 of the then judge's judgment, and then paragraph 175 of the judgment, which contradicts the position he takes at 255. In other words, there is evidence of a pilot raising concerns about the statutory retirement age versus 65 point.
Yes.
My lord and lady, I do want to address you on 3 points of law, and just to summarise, and I won't take more than about 5 to 10 minutes to do that.
Don't worry at all.
I appreciate that, thank you. So, first of all, if I can just come back to the most recent authority of McMahon. We haven't spent a huge amount of time on it, but in fact it is very interesting in terms of how far it goes to protect the interests of those on a PHI scheme. It's tab 26, which is responding to the authorities. I would ask you to read that in due course. What essentially happens there is, and as you've already been taking it to my learned friend Moylan Jr., the individual who should have got PHI actually never got any payments from the company, and they terminated her for incapacity, having not paid her anything. Having not, they say, I think it's an administrative fault, they say they haven't got the insurance that should have gone behind the scheme that they promised. And the Court of Session found that nonetheless she was entitled to it, not just in relation to the period when she was employed prior to dismissal, but post it. And the way they look at that interpretation, they effectively look at the relationship and the contract, and they construe that in order to find that she's entitled to that money. Now, the reason why I say that's of interest is the whole essence of PHI is that it's not about the salary, it's a different type of employment right. It's not simply any other employment term. And it's not been treated like that by the courts historically, which is why you have the long line of authorities that starts with Asphodin, which is cited in, if you wanted to go back over it, in the judgment in detail in the Tesco case. That's tab 24. I don't intend to go over it, but the reason why implied terms have been brought in to protect permanent health insurance claimants is by its very nature, is it runs effectively as an insurance to them, and that is completely understandable. I say that because Moylan has effectively tried to strip the essence of what this insurance, this right, this contractual right of these claimants is about. And he's tried to strip it down to, I submit, a way that I would strongly urge you not to. This is about a scheme that has been in place for almost 50 years at the point it was changed by the PIP. Pretty much untouched. And pretty much saying, through a variety of different words, that those in claim are entitled to those benefits indefinitely. That's essentially what the use of the word permanent means. And I obviously remind you of what Tesco says about permanent being more than just being able to amend by mutual consent and so forth. I ask you obviously to read that.
Can you give me the reference? Where does it say exactly that?
Well, it does, and I'm paraphrasing, and that's why I'll ask you to read it. I don't want to take you to it, because you've been taken to it twice already, so I'd ask you just to read those paragraphs that you have, paragraphs 39 onwards, in relation to what that particular clause is. But what is illustrative of that clause, the retained pay clause, is you may recollect it sets out when the entitlement to retained pay ended, and it specifically states the reference to by mutual consent. Now, you may recollect that right at the beginning, I accept it probably feels like quite a long time ago, I took you to the same paragraph essentially in this this PHI scheme at page 55 of the core bundle, where it sets out when the benefit's payable until, and it doesn't include reference to change at all. One might expect that to be the case and consistent with the Tesco clause if that was retained. Paragraph 3.1, I submit, is key to part of the context of understanding what paragraph 5.1 says. Ultimately, this case I submit is fairly straightforward in many ways. You need to look at paragraph 5.1, taking, as I submit, what this permanent health insurance scheme is about, the terms intent within it, looking at paragraph 5.1, the questions that's been asked by it, and what it answers. And in doing that, I think it's very clear that the second sentence is independent of the first. And
so just going back to your previous point, is the logic of your position that, because there's, I think this is a point that was made yesterday, but forgive me for just coming back to it, that even the individual can't agree to any change once they're in claim. Well, they can agree, but they won't be bound by their agreement. That seems unlikely.
My lord, that wasn't my point. My point is this idea of mutual consent between the two individuals of the contracts, the employer and the employer, they can agree.
Yes, no, well, okay, but why then? Well, perhaps it's just back to the fundamental point. Why is it any different if their union makes a change for them? Suppose, I mean, it looks very bad here because it's such a big change. Suppose there's obviously a bit of the scheme that's going wrong, not working well, needs a change, and the union agrees to, let's say it changes the escalator from 5% to 4.5%, but maybe gives some compensating benefit. So ultimately, the in-claim pilots aren't much worse off at all. They're different, but not much worse off. You say that can't be done. It's ineffective.
My lord, yes.
Yes, I see.
And
I think that has to be your position.
That's correct, to be consistent. But what I would say is
The great line is drawn between any kind of collectively agreed change as opposed to a mutually agreed change, as opposed to a change agreed at the individual level.
Yes, and going back to that, that there is a very, I submit, distinction to be made there, and that's really what runs through the Tesco case, is distinction between mutual consent and consent by way of collective bargaining for all of the reasons of the risk that collective bargaining carries with it, which is that these are effectively vulnerable pilots who are unable to work, and as a consequence of a trade-off by...
Are they unable to fly?
Unable to, well, yes, so unable to fly.
I mean, most of them are working, aren't they?
That's right, in a suited occupation under the picture.
Is he right about suited, by the way?
I haven't... I'm not actually sure.
Okay, well, we'll call it suited. We know an office occupation, effectively.
Yes, something that doesn't obviously involve the rigorous medical conditions of the pilot. And of course, it is a important. The pilots, they are, it's a vocational job, so losing that right to them is an incredibly upsetting and painful experience. We've talked about some of that and some of that recognition in the wording of the handbook itself. So it is a different, I say, qualitatively different issue of individual employer and employee agreeing something as something imposed by collective bargaining through which they have absolutely no control over, and that's what we see here. I just want to add to that. I think, just going back to the Wood versus Capita, in terms of the parts of the judgment that my learned friend is taking you through this morning, where the judge is looking at his interpretation of paragraph 5.1, you don't see the context that I would urge you to look at. So, and which I've spent some time yesterday morning taking you through. But that it starts really at paragraph 251, 252 at page 148, and then it runs on from paragraph 259 through. And what you see, I submit, is the judge very much focusing on the fact of collective bargaining having taken place in 2021 to inform his interpretation of the handbook, which was in 2015. And that really is the essence of the points being made in grounds 2 and 3. But ultimately, it all goes into the part I submit around why the judge is wrong on the construction, which is that, yes, there was a seminal provision, and yes, that was in place when the handbook was agreed in 2015. But just pause there and take a step back. The handbook had never been part of collective bargaining. It is part of the picture, but it is not the whole picture. And my submission to you is that the judge has overemphasised that, and to the neglect of other key parts that he should have brought to bear into considering the proper construction of paragraph 5.1. And again, taking that a step back here, and what I submit is that if he'd done that and he'd looked back at paragraph 5.1 and understood that the history, the context, the wording in the handbook itself, and brought that to bear on his construction, he would have concluded that any change necessarily incorporates change by collective bargaining. And that the second sentence of paragraph 5.1 was a freestanding protection for pilots that are in claim. And it is important that it is only for those in claim. So it's not that it's trying to protect thousands of pilots, it's for those who have already had crystallisation of their benefits and are being paid amounts on a monthly basis through PHI. And the risk to them is obviously huge, and we can see that from what has happened in this case, where you see Mr. Jones almost overnight having his monthly amounts reduced by half. And I just want to go back as I said, any change means just that. There is no linking word between the second sentence and the first sentence. And when you look at the wider question that section's being addressed to, it makes sense that how the second sentence is a broad protection. And in that way, we submit that the judge erred in law by the interpretation he adopted of the meaning of paragraph 5.1, the narrow meaning he adopted. And that's essentially the essence of the appeal. He looks at it through the lens of what happened in 2021, rather than looking at the situation as at 2015 and what was the intent of the individuals then. My lords and ladies, unless there's anything else I can assist you with, then those are my points of reply.
Yeah, I'm just checking against. I think the answer is suited jobs is. I found it in the evidence. It does actually mean. It is actually a term of art, meaning effectively office job or a job not flying anyway. And I just wanted to understand that just a little bit better about proportionate benefit. It's clearly explained by the judge, but have I understood correctly that if you are working, do have alternative employment of some sort, which I think can be TUI or somewhere else?
That's correct, yes.
You get half of the 75%, just absolutely. It's only the other half that may then be affected. And there's a complicated calculation to see how much of the other half, the other 37.5% you get. But the way it works is it's quite easy to get most of it. That's what the judge, I think, says.
Yes, I think you'd earn a certain amount of money. And it's about encouraging the individuals to try to go back out there and work, essentially.
Of course, yes, no.
And I think if there'd be certain individuals that would get the full 75% because of the nature of their...
Well, they can't work at all.
They can't work at all. But if you have some ability to work, it's about encouraging that so you can go out and earn and then...
Yeah, I understand all that, but I'm just getting to how it actually ends up, what you might be earning in the end.
Like my line of friend, I'm afraid I haven't looked...
Well, okay, but just take this simple case. Suppose 100%, so just make it easy. Suppose the pilot salary is 100,000. So the actual PHI benefit is 75%.
Yes.
You could have a case where you are working and earning quite a lot of money in your second job, your alternative job, without all the job satisfaction of being a pilot. You might well be earning, say, 80,000. Wait, let me finish. But you then get your half of your proportionate benefit on top. You get your 37. So you might actually end up earning more than you would be as a pilot. But there is a cap? That's what I couldn't find. I assumed there would be.
That's always been my understanding. It's capped at 75.
I think
yes, it's capped. I think it's offset.
Because what PIP introduced was that it took the cap off. That was one of the fundamental changes. But was a cap? But there was a minimum. That £10,000 amount I was saying. I think that is it. Yeah.
Whereabouts in the judgment is?
Is this in the trial bundle? No.
Whereabouts in the judgment? Well, I was hoping everyone told me that the judge has done a wonderful job, and I could find it all clearly explained by him.
4 bundles. There's that supplemental bundle 64. Yes. Supplemental bundle. Great.
Proportionate benefit guide.
The guide of proportionate benefit. Is that the? Yes. The bottom by the second whole bunch, my lord. You see, you cannot claim more than the full pay extra over the amount of proportionate benefit.
Sorry, where are we?
64.
64. The bottom by the second whole bunch.
I see.
But as I understand, if you earned too much, you wouldn't get it. Is that right? The second bit of it? Yeah. Yeah, and there's paragraph 195 of the judge's decision as well, my lord, that deals with, I think, just so you have those paragraphs where he deals with it.
Well, I have got those. I was looking primarily at 26 to 29. It's 175, you were saying?
95.
195.
Well, there are submissions there. There are submissions.
Yeah, hang on, well, let me just look. Yes, I see. It's a perverse incentive whereby it's said to be whereby the less that an in-claim pilot earned, the closer to a full benefit entitlement he or she received. But they will never get under the scheme more than 75%. Is that the point?
They can never get more than 75 for the 37.5 and the 37.5.
Yes.
The second 37.5, if you earn more than, I think it was about £10,000, it would then, that second 37.5% would then come down.
Yeah. And I was asking a slightly different question. If you find another job within TUI or somewhere else, which pays you 100,000 a year, and then you clearly would only get half of your proportionate, half of the benefits, you would get 37.5%, but you will get that.
Yes, I think that's right, isn't it?
Yeah.
I think you would lose the second half because you've earned too much.
Yeah, of course, I
But
understand.
the
that.
first, I think, yeah, because you're incapacitated as a pilot.
Yeah, I'm not saying he's wrong.
No, you're trying to understand.
No, I'm just trying to understand, and I think I have understood.
Yes.
And in the unlikely event that I'm wrong, we can always check it with you later. But that gives you what I wanted to know.
And my Lord, can I just make a comment on the submissions at paragraph 195, which we've taken to it, which is around the point being made by my Lord in submissions was around it being a perverse incentive. Of course, just to put that in context, it wasn't something that had been put in place by TUI for decades. But at this point in time, in 2021 or 2022, they decide that they don't like it anymore.
No,
And that's
I understand, and please don't, you won't get me wrong, I don't want anyone in court to think that we are going to take sides on whether it was right or wrong to do this. It's a legal question whether they were entitled to do it. But it's still helpful to understand how it came about.
Of course.
And that's a limited interest I have in this. So you certainly won't find any judgment that I write saying, the most it might say is there was a view it was a perverse incentive, not that it definitely was.
Oh, I'm grateful. Thank you.
Thank you. Thank you all very much for your respective submissions. We are, of course, reserving our judgments. You'll receive them in draft in due course for the usual limited purposes, which, as you will know, are to correct our grammar and for the purposes of agreeing an order. But if you can't agree the order, we will deal with any outstanding matters on paper. So thank you very much, and thank you for accommodating your submissions within a day and a half. So thank you very much.
All rise, favourable.